School of Management Studies IGNOU presents an audiobook on the course MMPC-013 Business Law for MBA program. Block 5 Intellectual Property and Data Management. Unit 10 Intellectual Property Rights. Part 1.
After completing this unit, you should be able to understand the meaning of intellectual property, explain the need for protecting intellectual property, and describe the different types of intellectual property. Introduction. We live in a world surrounded by diverse types of intellectual property rights. The book you read, the songs you hear, the instruments you use, and the diverse apps you are utilizing on your phone are just some of the many kinds of works which might be or which might have been protected under different kinds of intellectual property protection. Thanks to the frequent appearances of the term intellectual property in mainstream media as well as everyday conversations, it has by now become familiar among a substantial segment of the public. However, as in the case of the parable of blind men and an elephant, different people perceive intellectual property very differently depending on their source of information and their day-to-day interactions with different types of intellectual property or IP. For some, it is that branch of law which protects trade names or trade symbols, while for some, it is a branch of law that protects technological innovations. For others, it may be a branch of law that protects movies and books, but many of them might find it difficult to define what IP is. Part of the reason for the diverging perceptions on IP and the difficulty in defining the term is the constant expansion of the subject matter covered under this area of law. Thanks to the expansion of the subject matter over the years, it has become increasingly difficult to find common elements in all types of IP that can provide a comprehensive definition for the term. Hence, one of the first things to remember is that IP is not a single homogeneous body of law, but rather a term that attempts to collectively describe a number of areas of law with distinctive characteristics. The next section in this unit will provide learners an overview of some of the prominent definitions of IP to showcase its vast and dynamic character. Further, the discussions in the upcoming sections seek to encourage the learners to critically analyze whether it would ever be possible to have one common definition for IP. Intellectual property. There is no universally accepted definition of intellectual property. This is not surprising as it is nearly impossible to find one definition that can comprehensively cover all the subject matters that are currently considered as intellectual property. The World Intellectual Property Organization or WIPO has provided a relatively more comprehensive definition which goes as, and I quote, "Intellectual property or IP refers to creations of the mind such as inventions, literary and artistic works, designs and symbols, names and images used in commerce." Unquote. Some of the scholars like William Fisher highlight the fact that intellectual property is not a single homogeneous law when he says that the term intellectual property refers to a loose cluster of legal doctrines that regulate the uses of different sorts of ideas and insignia. However, if the term intellectual property refers to a loose cluster of legal doctrines, then it becomes pertinent to ask when we can call something as intellectual property. According to Bentley and Sherman, the term intellectual adjective indicates the character of some of the material this area of law protects, that is, products of human mind or intellect, and the term property indicates the form of regulation, that is, the grant of exclusive rights which operate in a manner similar to property rights over tangibles. Different countries protect these diverse creations of the mind under different branches of law, such as patent law, copyright law, trademark law, and design law. Together, they are often referred to as intellectual property laws, though it needs to be kept in mind that it is becoming increasingly difficult to find common theoretical justifications for all such branches of law, and that there are major differences between the legal and economic foundations of these laws. Justification for protecting intellectual property. While there are different theoretical rationales for affording legal protection to different types of IP, the most widely used one is the incentive theory, also known as welfare theory. According to the proponents of this theory, most information products like books or music have two characteristics of public goods. The first characteristic is the non-rivalrous character in consumption. We say that a good has non-rivalrous character in consumption when more than one person is able to use the good simultaneously without affecting the possibilities of consumption of that good by another. For example, a digital copy of a book which is stored on the cloud could be read by more than one person, and each person would be able to read the book without diminishing the possibilities of enjoyment of reading of that book by another. On the other hand, if the book is in physical form or hard copy, only one person might be able to use that copy at a time. Most information products have non-rivalrous character in consumption. The second characteristic is relative non-excludability. It is relatively hard to exclude people from the consumption of information goods. This is a particularly important challenge as many information goods also have strong positive externalities. Economists argue that because of these public goods characteristics, inventors or creators will not have the incentives to create information products, and there will ultimately be underproduction of information goods. To address this issue of underproduction, the economists suggest that there should be at least some legal protection against copying. The legal protection suitable for different information products would have to be fine-tuned both in terms of duration of protection and scope of protection, keeping in mind both the requirements of protecting the incentives for production of such goods as well as the broader interest of the society in getting access to such products. Most laws that come under the broader umbrella of IP laws, particularly patents and copyrights, can be seen attempting to seek this fundamental balance through diverse measures such as limited term protection and exceptions to infringement. In the context of trademarks, there are two commonly cited economic arguments. Firstly, trademarks can reduce consumer search costs. In the absence of trademarks, consumers may have to spend substantial amount of time and efforts to identify a product that they wish to consume. Secondly, in the absence of trademark protection, there may not be much incentives for producers to maintain or improve the quality of their products or services. In other words, trademarks have a self-enforcing characteristic when it comes to quality improvements. Types of intellectual property. As indicated earlier, IP law is not a homogeneous body of law, but rather a collection of distinct but related legal doctrines covering diverse subject matters. This subsection will explore the basic aspects of some of the major types of IP. Patents. A patent is a limited term monopoly granted for an invention in return for the disclosure of the invention to the public. In India, patents are governed by the Patents Act 1970 and registration is mandatory for patent protection. Patents are granted after a rigorous examination process which involves different steps. A patent application will contain the title of the invention, description of the invention in a manner in which a person skilled in the art could work or reproduce that invention, and a set of claims that defines the legal boundaries of the invention. The term of patent protection in India is 20 years from the date of filing of the application. During the term of protection, patents ensure that the concerned invention cannot be made, sold, distributed, or used without the consent of the patent owner. Once the term of protection is over, the patents enter the public domain and anyone can use the invention in any manner they like. A patentable invention can be related to a product or a process. To be considered as an invention for the purpose of patent law, there are three general requirements. Number 1, novelty. Number 2, inventive step. And number 3, industrial application. It is also important to ensure that the concerned product or process is not a specifically excluded subject matter under the relevant patent statute. In India, Section 3 of the Patents Act 1970 has provided a long list of exclusions from patent protection. These exclusions are based on diverse public policy reasons. Similarly, Section 4 of the Patents Act provides that inventions relating to atomic energy which fall within subsection 1 of Section 20 of the Atomic Energy Act 1962 are not patentable. While the term novelty has not been defined under the Patents Act 1970, the standards of novelty followed in India are clarified through Section 2, Clause 1(1) of the statute which has defined new invention. As per this definition, new invention means, and I quote, any invention or technology which has not been anticipated by publication in any document or used in the country or elsewhere in the world before the date of filing of patent application with complete specification, that is, the subject matter has not fallen in public domain or that it does not form part of the state of the art. Unquote. In other words, publication of the details of the invention in any document or use of the invention in any part of the globe can negate novelty, and the patent application may be rejected on grounds of lack of novelty. However, it must be noted that novelty has to be determined in the light of a single prior art reference, and mosaicing is not permitted in novelty analysis. In other words, compiling different documents and then comparing it with the technological features disclosed in the application is not allowed. The cited prior art should disclose the invention either explicitly or implicitly. There also needs to be a complete match between all the technological features as disclosed in the application and the cited single prior art reference. However, the statute has also provided certain specific exceptions to anticipation. The second requirement, that is inventive step, is the toughest requirement to meet among the three essential factors in patentability. In India, the Patents Act 1970 defines inventive step as, and I quote, a feature of an invention that involves technical advance as compared to the existing knowledge or having economic significance or both, and that makes the invention not obvious to a person skilled in the art, unquote. Inventive step analysis is done from the hypothetical construct of a person skilled in the art, that is PSITA. The statute hasn't provided any definition for the terms technical advancement or economic significance. The statute also does not provide any specific guidelines for determining non-obviousness from the point of view of a person skilled in the art. However, the courts have evolved certain guidelines in this regard, and an important decision in this regard is Biswanath Prasad Radheshyam versus Hindustan Metal Industries, a decision of the Supreme Court of India. In this decision, the court clarified that whether an alleged invention involves an inventive step will be a mixed question of law and fact. The answer would invariably depend on the facts and circumstances of each application. The third requirement for patentability, that is capable of industrial application, is relatively easier to meet in most circumstances. As per Section 2, Clause 1 AC of Patents Act 1970, capable of industrial application in relation to an invention means that the invention is capable of being made or used in an industry. It needs to be reminded that even if an applicant can show that the application meets all the three requirements of patentability to be successful in a patent application, it is also important to ensure that the subject matter of the invention is not a specifically excluded subject matter under Indian patent law. As discussed earlier, India has a relatively long list of excluded subject matter under Section 3 of the Patents Act 1970. The list includes business models, computer programs per se, and traditional knowledge. Accordingly, if the application belongs to any of those specifically excluded subject matter, it is bound to be rejected. Copyright. Copyright protects creative and artistic works. The diverse kind of works that can be protected by copyright include books, music, movies, paintings, sculptures, and computer software. In India, copyright is governed by the Copyright Act 1957. Copyright provides a bundle of rights for the creators, and the types of rights provided would vary with the subject matter. For example, the bundle of rights provided under Indian copyright law for creators of literary works are: Number 1. Right to reproduce the work in any material form, including the storing of it in any medium by electronic means. Number 2. Right to issue copies of the work to the public, not being copies already in circulation. Number 3. Right to perform the work in public or communicate it to the public. Number 4. Right to make any cinematograph film or sound recording in respect of the work. Number 5. Right to make any translation of the work. Number 6. Right to make any adaptation of the work. And number 7. Right to do any of all the mentioned so far, in relation to a translation or an adaptation of the work. On the other hand, for cinematograph films, the bundle of rights provided under Indian copyright law are only: number 1, right to make a copy of the film including a photograph of any image forming part thereof or storing of it in any medium by electronic or other means. Number 2, right to sell or give on commercial rental or offer for sale or for such rental any copy of the film. And number 3, right to communicate the film to the public. As the example illustrates, depending on the subject matter, the type of rights and the extent of rights granted under copyright law to the creators would vary substantially. Apart from these economic rights, some of the jurisdictions like India also strongly protect certain non-economic rights of creators, and they are known as moral rights. Under Copyright Act 1957, moral rights are referred to as authors' special rights. The moral rights protected under Copyright Act 1957 are: number 1, right of attribution, that is, right to be attributed as the author of her work, and number 2, right of integrity, that is, right to prevent or claim damages with regard to any changes made in the work that could harm the reputation of the creator. Unlike patents, registration is not mandatory for receiving copyright protection. Copyright protection is received the moment a copyrightable work is created. However, for most categories of works like literary, dramatic, musical, and artistic works to be copyrightable, the work needs to meet the requirements of originality. To meet the requirement of originality, a work must be an independent creation and it should show some minimal amount of creativity. However, different jurisdictions follow different standards for the amount of creativity required to meet the requirements of originality. In India, for a very long time, the courts followed the so-called sweat of the brow approach, which focused primarily on the labor put in by the creators. But in the landmark decision of the Indian Supreme Court in Eastern Book Company versus D.B. Modak, the court rejected the sweat of the brow doctrine explicitly and adopted the skill and judgment test, which was laid down in the Canadian Supreme Court decision in CCH Canadian versus Law Society of Upper Canada. As pointed out by the Supreme Court, as long as the work originated from the author and not copied from another source, and the work is a product of exercise of skill and judgment, it can meet the requirements of originality under Indian copyright law. In the EBC decision, the court also clarified that creative works by definition are original and are protected by copyright, but creativity is not required in order to render a work original. In other words, the threshold level for meeting originality is not that high under Indian copyright law, and works would qualify for protection as long as they can meet the minimum standards suggested in the EBC case. As compared to patents, the duration of protection is much longer in the case of copyright. The term copyright protection varies with the subject matter, and duration for different subject matter under Indian copyright law are dealt with in Chapter 5 of the Copyright Act 1957. The copyright protection for literary, dramatic, musical, or artistic works other than a photograph published within the lifetime of the author continue until 60 years from the beginning of the calendar year next following the year in which the author dies. The term of protection for photographs under Indian copyright law subsists until 60 years from the beginning of the calendar year next following the year in which the photograph is published. For cinematograph films, the term of protection is until 60 years from the beginning of the calendar year next following the year in which the film is published. The term of protection provided for sound recordings is 60 years from the beginning of the calendar year next following the year in which the sound recording is published. It is also important to note that moral rights protection in India extend beyond the term of copyright protection. Collective management of rights is very common in the case of copyright, as it is difficult to monitor and enforce rights at the individual level. For this purpose, different copyright societies are established and they collectively manage the rights of authors. Some of the famous copyright societies include Indian Performing Rights Society, that is IPRS, which deals with the rights of authors, composers, and publishers of music. While most discussions on copyright focus on the rights of creators of copyrighted works, it is also important to note that copyright law is not just about the rights of creators. Copyright law also provides many rights to the users of copyrighted works, and they appear in the form of exceptions and limitations to copyright. In India, Section 52 of the Copyright Act 1957 provides a long list of exceptions to copyright infringement. While Section 52 Clause 1A of Copyright Act 1957, which is known as the Fair Dealing Exception, provides a relatively broad and open-minded exception, Section 52 Clause 1B to Section 52 Clause 1ZC provides a long list of enumerated exceptions that cater to diverse access requirements in the country. For example, Section 52 Clause 1I provides an important educational use exception. In a country like India, wherein the vast majority of students cannot afford to buy expensive reference books, such exceptions play an important role in ensuring access to knowledge.
We were listening to the audiobook by the School of Management Studies IGNOU for MBA program. Course code MMPC-013 Business Law. Course coordinator Professor K. Ravi Shankar. Voiceover by Harpreet Kaur. Edited by Savita Rana. Program assisted by Tarannum Jahan and Jagbandhu Jana. Program produced by Dr. Manoj Kumar Singh. This program was brought to you by Electronic Media Production Center of Indira Gandhi National Open University.